It's an honor, but not nearly so much a pleasure as it is sometimes to talk with you today and give you a case update. I'm going to use a little prerogative and try to hit on several points and yet skip one of the main cases that I had identified in the materials, pretty much skip. There have been a lot of legal developments, and there's some that represent true potential milestones, and we just sort of sit and wait as to what's going to happen. First, well, got to be a little slower. Just want to remind you that you should really listen to your own lawyer, and if I am your own lawyer, ask me again. But just to be careful. And the summaries that are contained in your materials are pretty much just that, and one lawyer's shot at trying to explain some complicated issues. I've identified in the materials and defer to them to some extent with regard to three major developments. The AICPA's suit with the IRS, the Turner versus National Counsel, and North Carolina State Board of Dental Examiners. You probably read news about the AICPA suit with the IRS, and I'll give you an update and some insight on that. Turner is the one I'm going to skip over somewhat and defer to the materials. Just say that by and large it's a case involving the Americans with Disability Act, and the court left open some possibility for some leeway with regard to accommodations and not a strict application of the protections of the ADA in the licensing arena. And then I want to substantively give you an update with regard to the FTC case against the North Carolina Board of Dental Examiners for several reasons because of the potential impact of that case. But first, because there have been so many developments over the year that deserve at least a few words, I want to touch on them. Some of these, and don't worry, this will only take 1 or 2 or 20 or 30 minutes. Just quickly, the Davis case, Louisiana case, the bottom line from that one I found interesting was that the court was saying they were willing to defer to the board, but only on interpretations of its own rules and not necessarily statutes. In the Flatnum case, interesting there is that there was an effort to obtain some board records, but one of the observations the court made was that the fact of whether or not someone passed the CPA exam on their first attempt was not relevant as to whether or not they were an appropriate expert in a particular matter of litigation. A scary thought, but if it does become relevant at some point. The Gutraj case, I'm sure I'm not pronouncing that correctly, but basically for those that might be relevant to, the court concluded that a hearing was not required for a board to refuse to renew someone who didn't pay their dues on time. The Joanne Howard and Associates case, I'm sorry, I misstated the Flatnum case. The Flatnum was one in which it was worse than I had portrayed. Flatnum, state of California, that was where the suit and the court reached the conclusion that the board members were immune, the assistant attorney general or deputy attorney general could be immune from suit, but that the executive director might not be. So think about that. I apologize for the confusion there. Yeah. Did I get your attention? That the executive director might not be immune from suit under certain circumstances. So that might be somewhat limited by that state's laws. We'll see. the importance of that conclusion becomes all the more relevant later on in the discussion I'll give to you. The case involving the expert witness and the qualification of the expert witness was actually the Joanne Howard case. If you saw my notes up here, you would feel sorry for me, but I was trying to fit a lot into one. The Simic case here was again, a late renewal case, but the court did, and the court said that that might be a per se violation, but on the other hand, that there was not authority to refuse to consider a late request. So, and again, John Patterson can probably shed some more light on that one, but just trying to move through, again, somewhat quickly. The next case is in Pennsylvania. That was a case in which someone had failed to respond to a board complaint, and the failure to respond constituted a waiver of certain defenses, including one of latches, which is a concept that the board had waited too long to bring the action. So anyway, the board prevailed with regard to that one. The next few cases that I have on that short list, Klein versus Bashir, it's a Kentucky case, not involving a board of accountancy, and probably different on statute and on constitutional grounds. But there, just to let you know, the court there did rule that the transfer of agency surplus funds was not unconstitutional. And they'd taken funds that were collected as dues or fees and had put them into the general fund. Again, might be somewhat distinguishable, but wanted to be sure you were aware of that one. The application of YL, again, what does massage and bodywork therapy have to do with accountancy? On a good day, probably a lot, but for this particular one, it was just interesting in that here was someone who had a language issue, had other problems, and the board determined that, in fact, her failure to disclose one matter on her application was unintentional misrepresentation. However, a court ruled that that was sufficient in itself to justify denying a license to that individual. So I think most of us, by reflex, think in terms of intentional or grossly negligent misrepresentations. This is somewhat different. In Ray Garcia, I talked about last year, and just to give you an update, that was the one where it involved a challenge over the applications for licensure by people who did not have a lawful permanent residence or other immigration status issues. And the court has said that if there is a law in your state specifically commanding that, then you can allow licensure even though the federal law suggests otherwise, because the federal law allowed for that state carve-out. In the meantime, other states have moved in that direction, mainly in the area of practice of law, but California most recently passed a law that applies to really, I think, all licensing, including particularly accountancy, so that you would have a licensing of applicants regardless of the legality of their immigration status. That could pose ultimately some challenge to mobility, poses some problem for states that have exactly the opposite position as well. And then finally, CommScope, and some of these, by the way, are within the last few days. CommScope is out of North Carolina, one that was issued yesterday. And in that one, just to note, the court basically was coming pretty close to concluding that auditors have a per se fiduciary duty to their clients, which raises the bar in many ways. So I wanted to give you that little smattering, the assorted chocolates collection of recent case developments, and give you a bit of a background overview, as it were. Next, let's chat about the AICPA versus IRS. And the background, if you may recall, was that the IRS had issued some mandatory provisions that provided for a higher standard for tax preparers. Those requirements, those rules were challenged in the Loving case, and that case proceeded, and the court ultimately rejected the IRS's rules with regard to tax preparers and the mandatory program, which provided for, among other things, mandatory education or continuing professional education. Subsequent to that, the IRS embarked upon pretty much the same program on a voluntary basis and established a proof of having completed a certificate of completion of the continuing education programs, but set it out as a voluntary program. Many of us have a hunch that there's not much in the IRS's world that's truly voluntary, but nevertheless, it was out there as a voluntary program. The American Institute of CPAs filed an action challenging the IRS's new voluntary program. The case that was first, the IRS filed a motion to dismiss on the basis of standing, saying that regardless of whatever merits there might be to the challenge of these regulations and this new voluntary program, the AICPA itself was not the right party to be standing in front of the court in this matter. Some of the major thrusts of the AICPA's contentions turned around the imposition on CPA firms who had employed tax preparers in their firms and the financial impact of attempting to comply. They also, in order to show standing, asserted that there were going to be competitive impacts upon CPA firms as well. And then finally, they asserted here that the IRS's program creates new categories of tax return preparers who would be waiving IRS credentials in the faces of consumers, and that rapid proliferation of these categories will confuse consumers. That consumers will believe that tax return preparers who have complied with the rules are more experienced or preferred vendors of the IRS, as consumers do not have an understanding of the licensing and educational requirements to be a licensed CPA versus a tax preparer who has complied with AFS rules. And so that was the third argument on that. It was a shot at the AICPA showing that there's a public protection element here. Now, in the meantime, of course, the IRS moved to dismiss. AICPA countered. It predominantly was on technical grounds, this third point being somewhat overshadowed. And in the meantime, after that, the AICPA moved for summary judgment in its own right. But before there could be responses or even a chance, if state boards or NASBA were considering it, to file an amicus on any point, the court ruled last week that the AICPA's case would be dismissed. And basically, one of the important points of the court's decision was that conclusory allegations of injury from undefined consumer confusion are insufficient. Now, do state boards, NASBA, have an interest? I.e., why do we care? Why am I talking about this particular case when we had that whole list of other fun cases up there? Well, there are a few points. First of all, it might be contrary to the Uniform Accountancy Act, and for that matter, a number of state statutes. Because remember, in the Uniform Accountancy Act, it spells out that pretty much that anyone who is engaging in things which are professional services, which is defined very broadly in the UAA to include anything that pretty much that accountants are doing, that anyone engaged in those services cannot use other titles They cannot use the CPA or anything like that, or CA or anything like that, unless they're licensed. They cannot use other things implying that they have special credentials in that regard. In fact, the UAA and many states' statutes specifically call out the enrolled agent provision and saying, you can only use that, but only in certain circumstances, and pointing specifically to enrolled agents. Of course, there's no statute talking about the tax preparers who have obtained the education, the continuing education the IRS has prescribed. So, could pose some problems under the UAA. The thinking behind the UAA was the potential or likelihood of confusion in the public's mind with regard to qualifications. Another point was that state boards not only discipline licensees, but they're also authorized to enforce the unauthorized use of title laws. So the statute's out there, but the boards are the front line of seeking injunctive relief, referring it to criminal prosecution, and if there's an instance where someone is taking the proof that they had the continuing education, some were in the press and even in some of the IRS's materials calling it a form of certification or a certificate of completion. Some could use that and attempt to mislead or at least lead to confusion in the public's mind as to who was qualified and whether or not there were special qualifications in that arena. Additionally, at least 4 of our states, state boards directly regulate tax preparers. They have that as part of their responsibility and their jurisdiction. And then I guess in the category of will it impair enforcement, sometimes in court you live by the example of the contrary, and here you'd have another instance. If you recall back to Ibanez from many years ago, the Supreme Court had held that since it was true that she had the certified financial planner and indeed had the CPA title, even though she was using it in a law firm and not in a practice of accounting, that since it was the truth, she could use it. And if someone truthfully is saying that they have a certificate showing that they complied with IRS special requirements for special recognition, if carefully worded, could be the truth. Does this pose a problem not only with regard to enforcement of this matter, but also with regard to other enforcement against anyone else who might be illegally practicing or misrepresenting their qualifications in the field of accounting? You got to remember, with the 3rd edition forward of the UAA, we don't define the practice of accounting. Many states still have reserved that definition in their statutes, but we don't use it in the UAA, so it's not a clear and separate something unto itself. As part of the notion of CPA is a CPA, it means that whatever you're doing in trading upon the title, you're subject to board authority and compliance with certain rules, but it also makes the protection of the CPA title and things that sound like that, certified, otherwise chartered, all the more important going forward. So the bottom line on this is I don't know yet if the AICPA intends to appeal or to request reconsideration of the court's decision. The judge seemed fairly strong in his position, so I suspect that we may not see much movement of the court changing its mind. In fact, as the judge pointed out, that was the same judge that ruled in the Loving case, and they said, I think I know a thing or two about what's at stake here. So it would be a matter instead that might have to be appealed. Whether or not we, state boards, NASBA might have an interest at some point in weighing in on any part is going to be one that would be very carefully considered, obviously vetted, and also would be one that we'd have to be transparent with the IRS if we were to do something like that, because they are, after all, a fellow regulator. So we have to weigh both considerations. At the same time, there are things about the lower court's decision in this case that could be taken out of context and could be problematic later on for enforcement. Now, I touched just on, whoops, gotta be a little bit slower. On the Turner, I just mentioned that basically, refer you again to the materials there. I would add that the parties in that case had asked for the Supreme Court to take up the case, and the Supreme Court just in the last few days denied cert in that case. So the decision at the lower court level is the final decision. Basically, that there's some basis for a less stringent application of the Americans with Disabilities Act. So let's chat for a moment, a case that I apologize for having talked about before, but the good news is that every time around something changes, and something could very well change again. This was a case, by way of background, the North Carolina Board of Dentistry had a statute which included in its practice definition said that the removal of stains from teeth is the practice of dentistry. Based upon that, the board interpreted that to mean that the teeth whitening, where you were in their advertising, they said they were removing stains from teeth, that was the practice of dentistry, but had not taken a very proactive enforcement view of it. Then on one bright day in March, a news crew showed up on the board's doorsteps. Now, any of you EDs, staff, board members, imagine this. The news crew, camera ready, was asking the executive director why they weren't protecting the public, why they weren't enforcing the law. And you had an individual who had gone on before going on a cruise, they had had their teeth whitened at a local mall, a kiosk, using the little shops. And out on the cruise in the middle of the ocean, his gums started peeling off, and it was not good, not good. And they dropped him off in Mexico looking for a dentist who could, or someone who could help him. When he made his way back to North Carolina, he complained, he went to the news, and they took up his cause, and so that was part of it. There was a deposition of him, and it seemed credible. He had been harmed. The board, on the basis of that and some other complaints they had received, sent out their own investigator. The investigator went to a different kiosk, sat down, and while she was there to get the teeth whitening procedure, she noticed that the person, it was a kiosk in the middle of the mall, they had no running water, and the person that was going to be administering the treatment in her mouth did not use gloves. It was just going to be straight hands in. And just to compound a little bit more, she noticed that the individual that was going to administer the treatment had poison ivy on her hands. So, well, let me give you a little bit more context here, and that is that there's, as everyone knows, there's a federal, and most states have state antitrust laws. The federal antitrust law, there are two big parts. There's Sherman Act Section 1, Sherman Act Section 2. The Sherman Section 1 seems to be the main one at issue. It says that contracts, combinations, or conspiracies in restraint of trade are unlawful. It gives not only the U.S. Department of Justice the power to enforce, to pursue criminal sanctions, as well as injunctive relief, of course, and civil penalties. It also gives the Federal Trade Commission the power to enforce as well. And then, of course, it gives private litigants as well the power to file for suit and seek treble damages, $3 for every one, automatic, and even potentially attorney's fees as well. Now, just go back a few moments ago where I said something about people being immune, except maybe the executive directors. Pause on that thought, and let's go forward. Some of the major issues that have come up, and let me frame this here a bit. Okay, so Federal Trade Commission brings an action against the state board, accusing it of having violated the Sherman Act by contracting, conspiring. All the dentists of North Carolina conspired to drive the teeth whitener businesses out of business, and filed an administrative action against the board. That went to hearing. Now, the FTC is in Washington, D.C. The North Carolina Board of Dentistry is in North Carolina. The North Carolina board was required to defend it in Washington, D.C. It was a 4 or 5 week proceeding. So you can imagine the fun and the expense involved in that. It was held in front of an administrative law judge whose office is in the FTC building. Shockingly, the administrative law judge found against the board, and the board appealed to the full commission. The full commission affirmed its earlier decision to bring the case to begin with. So then it goes to the Fourth Circuit. Fourth Circuit ruled against the board. It was a 2+1 decision in which one was concurring for different reasons. But basically, the majority were saying nothing about public protection. They just saw it as an antitrust conspiracy. And at least one of the judges thought that it was important that in this particular instance, the board members, it was a licensee majority. 6 of the 8 board members were licensed dentists. And the way they got to be on the board was they were elected through a statutory process by all the dentists in the state. That was a different process. So they saw that, one judge saw that as important, the others did not. Of course, many others in almost all the other states, the members of that board, as well as our boards of accountancy, are appointed by some combination that includes governors, sometimes the legislature, and so forth. Although, hasten to add, often in consultation with state societies or with licensees and so forth. But the hanging point is a licensee majority. And I think all but 1 or 2 of those state boards of accountancy have licensee majorities. There are some practical reasons for that that don't involve teeth whitening, of course. One of them is that you need the expertise. Another is that it can be difficult to even find people who care, who want to be on a licensing board like that. Well, with those antitrust considerations in the back of your mind and the potential for injunctive relief, criminal sanctions, treble damages, and so forth, and the posture of the case, the board asked the U.S. Supreme Court to consider the case. And the matter, this particular case was argued just last month before the U.S. Supreme Court. The issue of licensee majority only came up slightly. The Inspector General, the Solicitor General, who was arguing for the FTC, basically said that they didn't regard that as an important point. They didn't care how the majority of licensees got there. It was the fact that they were a majority of licensees. There were those of us watching it from the accountancy point of view that were holding out a hope that it would be somewhat different and unique because of that election feature that's there. But the FTC, to its credit, had never really taken that position. They had pushed that the problem was the majority were licensees, and that was the essence of the problem. At the Supreme Court, if you look at the transcript, the words public protection do not appear. Not a big deal there, at least through the argument stage. It's difficult to get a read on exactly where the case will go, but another aspect of it that did concern the Supreme Court were cease and desist orders. Now, along the way, because the board was in the position of trying to enforce this law that prohibited removal of stains from teeth, by non-licensees, and because they were getting pounded by media as to why aren't you doing your job, why aren't you protecting the public, and because it was getting a little bit time-consuming and expensive and disproportionate compared to other responsibilities they have, such as keeping incompetent dentists out of practice, they decided to go to an easier route, and they would send out cease and desist letters. The Supreme Court refers to them as orders, but in most cases, they said they were letters. I know, and I've asked this before, and I'm not going to ask for a show of hands again, but I know that many of our state boards use cease and desist orders or letters. The North Carolina statute, the Dental Practice Act, does not specifically refer to cease and desist orders and does not specifically directly authorize the board to issue cease and desist orders. But to be clear, the dental board in this case was sending out letters that were, they didn't order anybody to do anything. They said, here is the law. We have received some information that you may be violating the law. Please notice the law and cooperate in any further investigation. That is essentially the bottom line. No padlocks, no insistence along those grounds or anything like that, but just sending out something that was informing people of what the statute said. And of course, the statute in part said that removing stains from teeth would have to be done by a dentist. And they didn't make that up. I mean, that was the statute, not a rule, not an interpretation. It was just there. But the cease and desist seemed to be a concern. Justice Ginsburg, one of her questions, the objection here is that the board was issuing a whole bunch of cease and desist orders. They had no authority to do that, no authority at all. Well, some of your AGs have probably opined to you that you have implicit authority to be sending out letters to people telling them to cease violating the law. May not be an order, may not immediately result in closing of doors, but it might be something out there. Some of you have implicit statutes out there. The board, before it had sent out the cease and desist, had actually gone into court and prevailed on 3 or 4 different occasions in stopping people from engaging in the unauthorized practice of dentistry. And it was using the cease and desist as sort of a kinder, gentler, quicker, cheaper way to enforce its law. But at any rate, that does seem part of what's there. If you're sending out cease and desist letters or orders, you probably want to look at them again and be very careful at how they're worded. I know some states have looked at it very carefully, and I think are doing it very well and doing it directly and correctly. Some send them as cease and desist consents, which in and of itself is different. It is not so much of a problem. Along the way, this is not the only case involving teeth whitening. I have to begin because what's the big deal? What are the concerns? Where does the public come in? In just last month, before the argument in the Supreme Court, a court in Alabama had issued a ruling in another teeth whitening challenge. Here, teeth whitening business providers had challenged the Alabama Dental Board's position on the matter, saying that that would constitute a violation of their constitutional rights and a number of other Alabama statutes. The court, in ruling in the board's favor, determined that the plaintiff's argument is that the primary effect of the Act's restriction on teeth whitening is to protect dentists from competition. The court finds that the plaintiff's argument is without merit. The factual record in this case demonstrates numerous actual or potential health or safety risks. The legislature should be concerned with protecting the oral health and safety of citizens. This is the rational basis for the statute. These are words, if you take out dentistry and you put in accountancy, architecture, engineering, law, they're the kinds of words you want to hear. That's what you're about. I mean, at all of these meetings, we repeatedly talk about public protection. When you take an oath to be a member of your board, to serve your board, one of the things you're doing is saying you're committing to public protection. And it's in that context. And the Alabama court seemed to understand it. Again, the words public protection, not even in the oral argument at the Supreme Court, not there, not in the majority opinion back in the Fourth Circuit as well. Well, what's the upshot? We'll have to wait 6 months or so before the Supreme Court actually rules, but in the meantime, the blogs and the press are out there. One of the headlines I saw was occupational licensing laws are a government racket. They didn't say dental practice laws. Occupational licensing laws are growth inhibiting and job limiting, injuring the economy while corrupting politics. They are residues of a mercantilist mentality, which was a residue of a feudal guild system, which was crony capitalism before there was capitalism. Now, is that some anonymous blogger? No, that was George Will, writing in the New York Times. So the opinions are out there, battle lines are constantly being redrawn, and the possibilities are somewhat disturbing, because you might just not only have to think about changing tactics if you're using for convenience cease and desist, but you might be changing who's going to be sitting in this room next year. Not just how they got here, but who's going to be here, who are going to be the ones that are making the decisions, setting up standards, rules, not just enforcement of unauthorized practice, but discipline with regard to licensees. Some of those aspects seem to bother the court, at least some members of the Supreme Court, so we don't know where it'll go, no way to really predict, but it could get bad. It could be a serious change, and regardless of political perspective, it could be a very expensive change in the sense of a deficit on public protection, and at the same time the expense now of having to hire the expertise for these boards to be able to do their business, do what they need to be doing. I think that when the decision is rendered, it's possible that we relax, that the executive directors who are no longer immune might be okay. Board members who have not necessarily been ruled as immune under the antitrust laws might be okay. On the other hand, we may have something commensurate to the challenges that we faced with the Ibanez decision. Although Ibanez was accused of a very interesting thing. She was accused of telling the truth. She had a CPA license. In the other instance, in the illegal practice, no one was claiming that they were secretly licensed. No one was, there were some that were wearing white lab coats to make it perhaps look like they were licensed. They even had licenses on the wall, but they were actually franchise licenses. So it's a very different thing. We could find ourselves either in a position where things are okay, or we have to roll up our sleeves. It depends yet on what the Supreme Court says and how it says it, is whether or not we're rolling up our sleeves of our shirts or the sleeves of our pants as to how we deal with the problem. We have to wade in, or we can just tackle it sitting down. But I think it does pose some interesting challenges going forward. I appreciate your attention. If there are any questions.
Thank you, Noel. I think you got the attention of some executive directors. Are there any questions of Noel? Okay.
Good.
There's one question coming. There are two questions coming. Please state your name and your state.
Noel over here.
No.
Sorry. Steve Richards from Alabama. On the North Carolina case, you said that in the argument for the Supreme Court, they did not argue public protection. What arguments did the board make to the Supreme Court?
Well, I guess I have to say is that the justices didn't mention public protection. Although I have to say that Justice Breyer did refer to public safety when expressing a concern about having people who were not licensed as neurosurgeons making determinations of what was competence or incompetence in that regard. So there was a hint of maybe a carve-out there, but nothing with regard to just simply public protection with regard to deception, that sort of thing. It was turned on that alone. The main arguments turned pretty much on whether or not the state has the prerogative to determine by licensing statutes how to protect its citizens. Now, in most of the states in this room, there have been licensing boards along the way that you have to wonder about. And in a couple of instances, in North Carolina, for example, there have been licensing boards that the court looked at them and said, not on antitrust grounds, but just on due process, equal protection grounds, that there's no basis in regulating or reserving to that particular line of work a state prerogative, a license that would be required. One instance was tile layers. Another was watch repair people. And so they've been stricken down before. So a lot of it was on the basis of the state's prerogative. The 10th Amendment wasn't really talked about, but the history of the antitrust exemption was, and I guess it would be useful, Steve, for further context to explain that since 1943, the Supreme Court had ruled in Parker versus Brown that state action was exempt from the federal antitrust laws. Their words were to the effect that they had looked at the antitrust statutes and that there was no mention of any intent to regulate the activity of states. And so that was a significant part of it. But there were also concerns over just the conspiratorial aspect of it and whether or not people had conspired. There was no evidence that they had secretly met or conspired. There was evidence that, and this might be pause for thought, but there was evidence that the board had a joint meeting with members of the state society and talked about potential rules and concerns about legislation, things like that. So there was a basis for converting that into thinking of it as conspiratorial.
On the side.
I'm Tom Wyrick, formerly from the Michigan Board. For a number of years, I served on the AICPA SEC Regs Committee, and what I do is I summarize the enforcement releases for their upcoming conferences. And as I was doing it for this coming year, I came across the case, not so much a question, but I think important for all members of the various boards. There was a Texas CPA firm that issued 38 audit reports when their license was lapsed. The SEC brought an enforcement action against them, a cease and desist order, and basically said that they could not appear before the commission. Administrative law judge overturned that, and now the SEC is trying to file additional briefs, trying to overturn the administrative law judge. And basically what the administrative law judge mentioned, that of the 38 audit reports, the SEC only brought mention of 5 of the issues where those reports were related to. So the administrative law judge has said, coming up with this theory in the SEC law about in connection with. And since they did not identify in their original case the 38 reports in connection with the various issues that they were related with, the administrative law judge overturned the decision. So it seems to be from this case, it's pretty important that all board members or the states when they bring an action, to make sure that they have all of the proper information included in that information. I don't know if you're familiar with this particular enforcement case.
I've heard about that. Some of it seemed to turn on the sort of the nexus of the alleged wrongdoing, where there were not sufficient details pled out as to whether or not that related to what the SEC was trying to accomplish in that case. Am I right on that?
Right.
Yeah. And it reminds me that there are cases out there where a board might lose a battle with regard to enforcement, discipline over someone, because the court determined that what the CPA was doing, even if it was wrong in some context, it was not directly impacting what they were licensed for. This was particularly important when there were all the definitions of the practice of accountancy. And it reminds me of the old North Carolina Supreme Court case where an attorney had been convicted of murder and managed to negotiate down so they didn't get the death penalty, so they were just sitting over there in central prison. And he was continuing to represent people and had a lot of clients. And the state bar wanted to take his license away. And the way the North Carolina prohibition or the North Carolina law with regard to unethical conduct read, it had to be in connection with your practice of law. And so the Supreme Court looked at the particular situation and said that the attorney had not murdered a client or a judge or another attorney, and therefore it was not in connection with the practice of law. So he had not done anything that was in connection with the statute, and the state bar had no authority to discipline, as it were. Yeah, but that's for lawyers. That's different.
We got one last question over here.
Good morning. Thank you, Noel. Recently, we've received from NASBA the listing of individuals holding out on the PTIN directory as CPAs, and all the states have received a report, and there's been some dialogue about that. Ultimately, a lot of the things that we'd be able to do is a cease and desist order for holding out. Any cautionary words other than going back to our legal counsel and assuring that indeed we have the authority to do that? I'm a little concerned based on the Supreme Court case where it indicates cease and desist may not be the best avenue. Our legal counsel usually says it's obviously, well, I won't say what they really say, it's a useless piece of paper, but obviously our licensees are all rattled about this on holding out, and it is a significant thing, but the tool we have in our tool chest currently is that cease and desist. Any cautionary words for us as a body before we go about this and get us all there?
Well, first of all, just great question. I would remind you that the Supreme Court has heard it, and you can read whatever you want to or can out of what the questions they asked, the comments they made, but they have not yet rendered their decision. So it's within the realm of possibility that the board prevails, and some pretty good strong, well, I think some strong arguments in that favor. So until they do, you can't be sure. The cautionary note, I think, is to do exactly what you've done, and that is talk to your attorney, look at the basis for the action you're taking. And if it's a cease and desist letter, you might just look at it closely to make sure someone is not acting solely on the basis of that letter if there's not more, or if you don't have direct authority for that particular form of letter, a cease and desist letter or order, as it were. So look at that. You're going to have to be careful. In the realm of unauthorized practice, unauthorized use of title, you're bumping up against not only the Sherman Act and antitrust, but also commercial free speech, and so you do have to be careful. But I'm confident that your attorney has looked at that before sending the letters, and hopefully you can just look at them again, make sure they're not misread, cannot be taken out of context, and do only what they intend to do in that regard. In some states, a handful, we actually will write someone, we'll say, hey, this is what we received, what's going on here, and ultimately close the matter. I think North Carolina's used this a few times with a consent to cease and desist, as it were.
Noel, thank you very much.
Sure thing.